It's AM 650's The Law Show, a comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Well, good morning and welcome to The Law Show here on AM 650. Joining us in studio from the firm Hobbs Giroday in Vancouver are David Hobbs and Ian Giroday. Good morning, gentlemen.
Good morning, Sterling.
Morning, Sterling. How are you?
I am well, thank you. David Hobbs, why don't we start with you and tell us a little bit about your firm, and then we'll get into wills and estates and all of that sort of thing. But Hobbs Giroday, Barristers and Solicitors, is an estates litigation firm. It's all about wills, isn't it?
Wills and estate litigation disputes, which can involve other aspects of estate disputes, executors and administrators and wills, beneficiaries, various issues that can come up.
But this is about after the fact. Wills, the making of wills, the drawing of wills, is not something the firm does, correct?
We don't draft wills. We deal with disputes that arise in connection with wills.
Okay. How long's the firm been around?
We've been 6-7 years. We're on Howe Street, just across from the courthouse, and Ian and I have been practicing together as Hobbs Giroday for 6-7 years, but we practiced together in other firms in years gone by.
We must be having fun, Sterling, because it's actually 8.5 years.
8.5 years. The time does fly, doesn't it? Ian, when people come to Hobbs Giroday with issues regarding estates and wills, what are the most common issues that they present to you?
Oh, wow. Probably the most common client is someone who's dissatisfied with a will of a relative who's recently deceased.
Okay, so someone has been left out, perhaps, or underserved in terms of a portion of the estate? Is that kind of dissatisfaction?
Yeah, that's certainly a significant portion of the people who come and see us, and that's sort of in the realm of whether they're a potential Wills Variation Act potential claimant.
Right.
And then sometimes they may have just concerns around the administration of the estate. It's taking too long. There's concern that perhaps the executor or administrator, there's maybe some mischief going on.
Mm-hmm. So typically, David, when a person dies, and the will is therefore an active issue, how long from the time of that person's passing on does it take for the will to be at that point where we see in the movies when everyone gathers in the lawyer's office for the reading, and then we find out how satisfied or not everyone named in the will is? What's the timeline typically associated with that process?
Well, it's usually not less than 6 months, and usually I would say maybe between 6 months, a year and a half. The whole process of from when a person passes away, that the probate is being dealt with, the estate is being distributed, the creditors are being paid, the clearance certificate from CRA is being received, and so on. So it's I would say 6 months to a year and a half type of process is a typical time frame.
And how, Ian, if you're named in a will as a beneficiary of someone's estate and goodwill, how long should it be before you should receive whatever has been allocated to you?
That can vary quite a bit, Sterling, but generally speaking, it takes anywhere from a couple of months to 4 or 5 months just to get the probate application into the registry.
Okay.
There may be a slight lag in getting the application granted, and there's sort of a rule of thumb that you don't bug the executor for a year.
Oh, okay.
But the reality is where estates are quite clean, there can be a partial distribution within a half year.
Oh, okay. So that a 6-month minimum before you get some word of what to expect, that kind of thing?
It can be a little quicker with a really clean estate.
Right.
Very few creditors, easily ascertainable, and assets that can be converted into money if it's really an issue of distributing shares of...
Oh, cool. Oh, yeah. Right. Okay. When we began the program, gentlemen, we were talking about we're going to focus a lot today on competency versus incompetency and as they relate to making a valid will. And as wills and estates litigators, I'm sure this is something that is a very much a part of your practice, David. So let's talk first of all, competency versus incompetency as they relate to a valid will. So let's go back to square one and talk about what is a valid will, and then we'll talk about the issues of competency versus incompetency. So what makes a valid will in 2013 in British Columbia?
Well, we have legislation in British Columbia relating to this, the Wills Act, and it sets out requirements for a valid will. The basic requirements are that it be in writing, that it be executed by the testator in the presence of two witnesses, and those two witnesses then sign the will as witnesses in the presence of each other and the testator as well.
Okay.
So those are what we refer to as the formalities of making a will that must be observed to have a valid will in that regard.
Okay, and so for purposes of understanding BC law, the word testator is a legal term for the guy or the person who makes the will maker, right?
Yeah, it derives from words like testament. The will is your last will and testament.
Oh, right, of course, yeah.
And so it's your statement of your wishes, and it's referred to as your testamentary wishes.
Okay. Now, Ian, when it comes to just following up on what David said about the last will and testament, now we immediately go through the Rolodex in our mind and we start seeing cliches like being of sound mind and body and all, and that's where we are with competency versus incompetency. So when it comes to someone coming to Hobbs Giroday going, now wait a second, I've got some real problems with this particular will because I don't think the will maker or the testator was, in charge, fully in charge of his or her faculties at the time this was made. And I want you people to go to bat for me. What do you do?
Well, just by way of background, Sterling, there's Wills Act formalities, and as David alluded to, you get that from written law from the Wills Act of British Columbia. Mm-hmm. The issue of competency actually isn't set out anywhere in a written statute.
Really?
It's what you call a common law test of capacity or competency, and it's derived from case law. In particular, there's a case from the 19th century England, which really is the standard that sets out the test for whether someone is capable of making a will or not, has the mental capacity to do so. And so the things that we're looking for when someone comes to us and says, I'm concerned about capacity, well, we're interested in knowing whether the will was drafted by a lawyer or whether it was done at home. Certainly we want to know about any medical conditions. Was there a form of dementia at play? Any other type of medical condition that might affect competency and so forth. And, we'll go from there.
And if there isn't a defined doctors saying, well, this person is in, such and such a stage of dementia or has Alzheimer's or some other crippling mental condition, if there's no evidence from professionals to support that, where do you go next?
Well, the first thing I'll say in response to that, Sterling, is interestingly, competency to make a will is a legal test, not a medical test.
Okay.
So one of the things that we would be looking for is the lawyer's file of the lawyer who prepared the will to see whether he or she properly assessed the will maker's capability to make a will.
That's an interesting area because you've just crossed from medicine to law,
right.
And now you're asking a lawyer or, David, possibly even a notary public in the process of helping a citizen draw up a will to assess somehow medically whether the person sitting opposite him or her is capable of in fact going forward and drawing a legal and legitimate will. That's bizarre.
Well, when you think about people late in life and the necessity to be able to make a will so that their estate can be distributed the way they wish, you don't want to make this too rigorous and too complex for people. Otherwise, poor people aren't going to be able to create a will. Mm. Now, on the other hand, the legal test and the lawyer who's meeting with this person and questioning them and so on is going to or should ask them certain questions to determine certain things. And those things generally are, does the person understand what their estate is, i.e. that they own a house or they have a bank account or how much money is in it, those sorts of things.
Is there a checklist that the Law Society or the government has created that when you're drawing up a will with a citizen, you are required to go through this formality of checking off whether, in your opinion at least, not being a medical person, this person is in fact capable and competent to prepare this will?
There's no checklist that is the checklist. But if you went to a medium or large size law firm or to a lawyer who regularly practices in that area, they probably would have a list of questions they typically ask that they've prepared.
Right.
But getting back to what's the legal test for competency, the person has to understand their estate and what it comprises. They have to understand what the will does. It may sound kind of simple, but really they need to understand that this is the thing that's going to dictate the distribution of their estate and who's going to get what and so on. That's the effect of the will when they pass away.
Right.
And they have to have a general idea of who typically would be the people expected that you would see in the distribution of their estate, who their children are, who their spouses are, and an appreciation of that. If a person comes in to a lawyer and they have children and they have a spouse and they tell the lawyer that they want the milkman to receive their estate, that's a bit of a red flag, and they would have to explain what that was all about and why they were doing that.
I'm curious.
Yeah, so it's those are the things that the lawyer should be asking. He should be recording the questions and the answers in his notes so that 20 years later, if someone wants to know whether the competency was tested or not, he's got notes and he can prove that, yes, I asked these questions and they were answered logically and so on.
And that's what you said, Ian. You first thing you do is go right for those files to find out if a client comes to you and says, there's a competency issue, I'm just not at all certain that this will was made by a person in charge, capable of doing precisely that. And so you said, okay, well, the first thing you're going to do is go to that will and the files of the individual who helped prepare the will, a lawyer or possibly a notary, and to see if those questions were in fact asked. How frequently do they not get asked?
More frequently than you would think.
Really?
They're, a good practitioner, legal practitioner, good notary who does a lot of wills, hopefully has a strong established practice of ensuring that they're asking the questions and recording the questions asked and answered in their file to ascertain the competency, the test that David just alluded to.
Right, yeah.
I should say that it's not, there's no God-given right to go get a wills file. If someone comes to see us and they're a relative, a beneficiary under the will, anyone but the executor of the will maker, of the deceased, will have to get the blessings of the executor or administrator of the will to get the lawyer to release it, because the file is privileged until there's some either court order releasing it or the executor agrees. And quite often in the sort of work we do, it's simply agreed that the will's file is clearly relevant to the issue of competency, and it must be released to the parties who have an interest in determining the issue.
David, how frequently do competency issues arise? I would assume that, as you referred to earlier, there are some instances where, as you said, the estate is clean. It's pretty easy to figure out. The will maker left a pretty clear indication of who gets what, and there's no complications. That how often does the reverse of that, where people challenge the mental capacity of the individual who made the will in the first place? Is it fairly common?
Well, I would answer that this way, Sterling. We have people contacting us maybe every week, every couple of weeks.
Really? Okay.
And I would say 30 to 50% of the time, their inquiry is a concern about the validity of a will, and I would say more often than not, it may be related to an issue of competency, and I think that's logical because you have elderly people, you have conditions like dementia, which we all know are common in our society, and these types of things are coming into play frequently in the making of wills or the changing of wills.
Right, right.
And so it flows from that you have a fairly common experience of people having concerns about changes. Quite often people have long-standing estate plans. It's a relevant inquiry in this discussion, and if a person's estate plan has been the same for many, many, many years,
Right.
and only changes in their 89th year or 90th year, in a way that is quite different than what it has always been.
Well, especially if the estate plan involves descendants who have been raised, perhaps, to expect to be moved into the family business or whatever, and then at the 11th hour in very old age, suddenly all that goes away. Then you start looking at what undue influence or what circumstances caused that bizarre change that late in life. Is that what you do?
Well, undue influence is a slightly different concept, but they're not unrelated. With dementia, if I become forgetful, then I may begin to believe that my children are not even visiting me anymore, not because they don't, but because I don't remember.
Right.
And I could go to a lawyer, and the lawyer could say, well, why are your children not in the will? And I might say, well, because they never visit me. But at the end of the day, we eventually learn that whole discussion is really caused by dementia, not by reality.
Right.
And so those are the types of things that we see, and lead to investigation and sometimes lawsuits and so on.
Need to take a break here. When we come back, we're going to talk more about competency and its opposite, obviously, as it relates to wills, and then we'll go through some of the more common questions that people have regarding this. We're talking with David Hobbs and Ian Giroday from the Vancouver estate litigation firm Hobbs Giroday, and we'll be back with lots more on The Law Show right after this.
There's more of the show still ahead. This is AM 650's The Law Show.